Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer at Samfiru Tumarkin LLP. I'm located in Toronto, Ontario. It's great to be back with you guys. I've hosted many of these Q&A sessions, and I always enjoy the opportunity to answer people's relevant employment law questions, things that are impacting all of you in your everyday work lives. That's what I'm here for. As you know, we host many of these question and answer sessions every single week across our offices. We have offices in Ontario, Alberta, and British Columbia, and our goal is to answer your questions to ensure that you are aware of your employment rights. And this is an amazing opportunity for you to ask all of your questions. I'm here for a half an hour to answer as many of them as possible. So please don't be shy and put forward your questions. As I usually do, before we dive into some questions, I'm going to start us off by talking about an important employment topic or employment law topic right now. And so what I would like to start off with is talking about another round of layoffs that our firm has become aware of by a company named Kinaxis. They're conducting another round of layoffs in 2024. And so there's a few things to keep in mind in these situations. First of all, when companies do mass rounds of layoffs like this, they usually adopt an approach in terms of paying severance, which is what I like to call a one-size-fits-all severance package. They'll say that for all employees who were terminated or laid off, you're going to be offered maybe 3 months of pay. And really each time is different. Sometimes a company might say 3 months, might say 8 months, might say 2 weeks. Each situation is different. And they'll say this applies to all employees. And of course, that's very legally problematic because each employee's severance pay is determined based on that employee's particular circumstances. So just because there's a lot of layoffs happening at once doesn't mean that the employer can just offer the same severance package, or what I say, a one-size-fits-all, to all employees who are impacted. And a severance package in Ontario is based on several factors. And that is the employee's age, the employee's length of service, the employee's position. We also like to look at the employee's remuneration package, right? What they're being compensated every year. And generally, how available are similar employment opportunities right now in the job market. That is what is considered for an employee's severance package. And employees can get up to 24 months of severance. Some employees are entitled to that. Some employees' maximum entitlement could be 10 months because each case is different. And so if you're an employee who has been terminated by Kinaxis, or you know someone who might be, please have them contact our firm because in most cases, they're not going to be offered the right amount of severance pay. And we are experts at getting people the severance pay that they're actually entitled to based on their particular circumstances. Okay. So that's a very important topic. There's a lot to get into there. I think before we dive into questions, I do want to mention one other thing that's very important. And in my practice, I get asked a question like this every day. And that is, how do you deal with a deadline to sign a severance package? Almost every termination letter that I read, and I've read hundreds of them, if not thousands, they have a deadline in them. And they say, here's a severance offer. And the company says, here's the offer that we're providing to you. And company's going to give you a week to respond. You have a week to accept our package. And if you don't accept it, well, then the package is off the table. Sometimes companies give a week. Sometimes companies give 10 days. Sometimes companies give 1 day. And the reason that it's different each time is because each time it's arbitrary. Companies don't just get to choose how long an employee has to accept a severance deal. Employees have 2 years to pursue their severance entitlements. So those deadlines are simply pressure tactics. And some people succumb to those pressure tactics and they feel like they have to sign the agreement or else they're going to lose the severance. It's absolutely not true. It almost never happens that you will lose your severance offer from the company if you don't sign by the deadline that they have put forward. So don't succumb to that pressure tactic. Don't worry about the deadline. Contact our firm if you've been terminated or you suspect you might be terminated soon. Let us know. We will help you negotiate the right amount of severance. But if you sign that deal, that offer, and then you contact us, there's very little that we can do because you've already accepted the deal. So you have to ensure that you contact us beforehand, and then we'll be very pleased to help you. So with that said, let us go into our questions. We already have a bunch, so I'm happy to see that. Let's deal with them. So we have a question on Facebook from Jessica. If my employer lets me go due to a permanent disability that is preventing a return to work, am I owed any severance? Yes, you are. Good question. And we do see this a lot. Certainly in my practice, I see it all the time where someone's let go. They might have been on disability for quite some time. They could be receiving long-term disability benefits, and then they're let go. They're terminated from their employer. So what happens then? Well, you're definitely owed severance. The question is how much. You might be owed your full severance package, which again, as I noted earlier, that could be up to 24 months of pay, depending on your age, position, remuneration, and availability of similar work. Could be 10 months, could be 24, could be 5 months. It will depend on your factors, but that would be your maximum severance entitlement based on those factors. It could be that if there is really no prospect of you being able to return to work because of your disability, you might only be owed your minimum severance entitlements. Each case is different. What I know for sure, and in fact, this week I dealt with it in with one of my clients, companies will often let people go and they will say, well, what has happened is your employment contract has become frustrated. So that's a legal term. And what it really means is that we can no longer employ you simply based on external circumstances. It's not your fault, employee. It's not our fault as the employer. It could be, and usually it is, a medical disability that I see in my practice. So they'll say, you've been on disability for 2 years. We can't employ you anymore. Your contract is now frustrated. We will pay you your minimum severance entitlements, but we don't have to pay you anymore. Well, the question is that true? Do they really only have to pay the minimum entitlements? And that will depend on really the medical documentation. What does the medical documentation say? Does it say that you can return to work in the foreseeable future? Or does it say there's really no prospect of you returning to work? If it is true that the documentation explicitly sets out there's no prospect of a return to work, it might be true that your employment has become frustrated and your employer will pay you the minimum entitlements. If they don't pay you the minimum entitlements, which happens often, absolutely let us know. But certainly also let us know if you think that you could have maybe gone back to work. There was a prospect of you returning to work. The medical documentation indicated that you might need some more time off, but in the future, your doctor thinks you might be able to go back to work. If that's the case, and your employer terminates you and claims that the employment contract has become frustrated, well, that's not true. There is a prospect of return to work, and therefore, if your employer is letting you go and claiming frustration, you'll be owed your full severance pay, not just the minimum amounts. You'll be owed more than the minimum amounts. And again, it happens all the time. I just dealt with it this week in my practice. An employer let my client go. They said they can't ever come back to work, and that wasn't true. The documentation didn't indicate that. So employers jump the gun in that regard often. And they shouldn't be doing that. But certainly, if they do, contact us and we will get you the compensation that you really deserve. So Jessica, I hope that answers your question. If you have a follow-up, please feel free to post it and I will get to it. We have a question on YouTube from P. Chan. If I'm unable to find childcare, they've exhausted all their options. They've asked their employer for an accommodation because of childcare reasons, and then they ask the employer says to the employee to resign. That's absolutely not allowed. No, you should not resign. If you resign your employment, you're not going to be owed anything. So let's put aside the accommodation issue for a minute, which is a real issue. But nevertheless, if you resign your employment, then even if your employer asks you to do that, if you do so, you're not entitled to anything anymore. You're not entitled to your severance pay because you voluntarily resigned. Now, of course, if you involuntarily resign, that would be what we call a termination, and then you would be owed your severance pay. But if you voluntarily resign, then you won't be owed anything. So certainly don't resign. And yes, you have a right to be accommodated. Your employer has a duty to accommodate you. And there's a very high level at which they have to accommodate you. There are some circumstances where they might say it causes us too much hardship as a company to accommodate you in the way that you're requesting, so we can't do that. And sometimes that's true, but very often it isn't. Usually employers will say, we can't accommodate you, and they'll cite some sort of reason, and it's not a good enough reason. They really do have a duty to accommodate you. In childcare situations, often it has to do with daycare. So, if it means that you have to leave work early, maybe start earlier, so you get your same 7.5 hours in of work per day, but you just shift the hours a little bit, that's a very reasonable accommodation in most cases, and we see that all the time. So if that is something feasible and your employer can implement that, but they're refusing to do so, A, it could be a termination of your employment, and B, it's a human rights issue, because you, under the Human Rights Code, have the right to be accommodated. Your employer has a duty to accommodate you, and for reasons such as childcare or family status, those are one of the reasons that are protected under the Human Rights Code. So absolutely don't resign. You do have rights here. If you want to set up a consultation, contact us as you see on the screen at help@employmentlawyer.ca, and we will arrange a consultation. We'll learn more about your case. You'll provide the relevant documentation and some details, and then we'll talk about it further and we could advise you. Okay. So we have a question on YouTube from Ira. If I don't sign my employer's severance offer by the requested date, what happens? Okay, so I dealt with that at the beginning of this session. If you don't sign your employer's severance offer by the requested date, what happens? Nothing happens. In almost every single case, your offer is not going to go away. Your employer is just putting a deadline in the termination letter to make you feel the pressure that you have to accept that offer. And usually that offer is not a good enough offer, almost always. So don't accept the offer. Contact us. Even if it's past the deadline, doesn't mean you're not entitled to your severance. You're entitled to your severance for 2 years. You have 2 years from the date of termination to pursue your severance entitlements, not the deadline that the employer puts in their letter. The employer is making up that deadline. Okay, so I hope I'm very clear about that. It's a very important thing for everyone to understand. Don't succumb to those pressure tactic deadlines. Okay, we have a question on YouTube from Jennifer. How do I document harassment, as I know I'm being pushed out of my job quietly without being fired, as the company doesn't want to pay me the severance that they owe me? Okay, so what Jennifer's saying is that she feels that the company is not terminating her employment because the company knows if they do that, then they have to pay severance. So what they're doing is making her life difficult at work, and she's experiencing harassment, and hoping that she will resign because of the bad environment or the harassment. And therefore, if she resigns, as I said earlier, she's not entitled to severance pay. So that is absolutely improper. And that's what we would call a constructive dismissal, Jennifer. So a constructive dismissal is where your employer is not adhering to the terms of employment. One of the terms of employment is that you're treated properly and working in an environment free of harassment. And so if your employer is harassing you, or if someone at the company is harassing you and your employer is not doing anything about it and they know about it, then that's a problem. and that would be a constructive dismissal. You don't just have to suffer through that toxic work environment. You can challenge it, and you can claim constructive dismissal, and you can pursue your full severance pay as if you had been terminated. So that's very important that everyone understand that. If you are facing some sort of harassment in the workplace, or it could be that it's not harassment, but your employer is doing something to change the terms of your employment, such as changing your pay or changing your hours or changing your work location. All of those things are changes. If you don't consent to them and your employer forces them on you, then that is a constructive dismissal, and it's a termination just like any other termination. You'd be entitled to your full severance pay. Now, Jennifer says, how do I document it? So difficult, sometimes difficult to do. What you really need to do is keep as much correspondence in writing as possible. Certainly if you're being harassed online in any way, by email, all of that correspondence is highly relevant. Make sure you keep record of it. Often it's not that easy, and you're not going to be harassed virtually or online or by email. It's often happening in person. So you have to raise it with your employer. If you have an HR team, raise it with HR. If there's a formal complaint that you submit, then you should absolutely do that. HR should be investigating it. And then let's see what happens with that investigation. If it really does, if your employer then does deal with the harassment in a satisfactory way, then excellent, that's good. If they don't, then that's a problem in and of itself, and you might still be in a situation of constructive dismissal. So like I said, keep as much correspondence as possible. Keep record of any complaints that you submit. If HR or the employer responds to your complaints, keep record of those. And sometimes it might entail you having to record a conversation. You are allowed to record a conversation if you are a participant in the conversation in Ontario. This is for Ontario. If in Ontario you are a participant in a conversation, let's say you're having a conversation with HR, you're fully involved in it, you're speaking in the conversation, that can be recorded. You can do it with their consent. You could also do it without their consent. So you don't have to get their consent to record the conversation, so long as you're a participant in it. And again, this applies to Ontario employees. So Jennifer, I hope that gives you something to work with, to know how to document harassment. Like I said, it's not always the easiest thing to do. Just keep record of as much as you can. Sometimes record conversations if you need to do that. All right. Okay. Let's move on. We have more questions here. So, we have a question from Renee on YouTube. Can you work for a company for 8 years in an open contract? And I guess you mean an indefinite contract when you say open. Then the company forces you into a 5-year fixed term contract, then terminates you after the 5 years without paying severance. Total of 13 years. So it's a good question. It depends. First of all, I certainly would have to see these contracts. I'd have to see what the indefinite contract said. I'd have to then see what the fixed term employment contract said. If they terminate you at the end of that, you'd be owed severance pay depending on what the contract says. Sometimes the contract will say you're not going to be owed severance pay, but often the contract is not going to be drafted in a legally appropriate manner to allow your employer to withhold the severance. So reviewing that contract will be very important in this situation. Presuming that the contracts don't limit your entitlements, yes, your full years of service will be counted. In this case, 13 years. And so you'd be considered a 13-year employee. And then that is one factor for determining how much severance you get. And as I mentioned earlier, there's also your age, your position, and we look at your remuneration or your compensation package as well. Okay, Renee, so I hope that's helpful. If you want us to review those contracts, then let's do that. We'll arrange a consultation. Again, help@employmentlawyer.ca. One thing I want to note, and you might have seen it on the screen throughout this session, is we have a very nifty tool called the Pocket Employment Lawyer. Part of the Pocket Employment Lawyer is a severance pay calculator. Okay, we've created a calculator that is free and anonymous. You can use it as many times as you want, and like I said, anonymous. You will answer some very simple questions about your employment. It will ask you all of those things that we talked about: your age, your length of service, your position, your compensation. And then we will determine for you how much severance you would be owed if you are let go. So feel free to use that if you've been terminated. Feel free to use it if you haven't been terminated and you think you might be terminated. Feel free to use it on behalf of a friend or family member who has been let go. Like I said, it's free and anonymous. Use the tool. It's an excellent tool. It gives you a good sense of how much severance you'll be owed. And then you'll contact us and we will help you obtain that amount of money. So check that out. Again, severance pay calculator. Okay, so we have a comment on LinkedIn from Sasha. I just got laid off, sitting in the parking lot. Well, then contact us. If you just got laid off, you've been offered a severance package, presumably, contact us, help@employmentlawyer.ca, and we will review it for you. And we will let you know if it's a good offer. Often it isn't a good offer, and we'll get you your proper severance. Okay, so as we wait for another couple of questions to come in, I want to talk about another important topic. And what that is, and it's very relevant right now because the laws are changing a little bit, is sick days. So sick days in Ontario. Are you allowed to take sick days? How many sick days do you get? So our legislation called the Employment Standards Act says that you do get sick days. You get 3 unpaid sick days per calendar year. And in order to qualify for that, you have to have been employed for at least 2 consecutive weeks. So if you've been employed for 3 days, you don't get to use your 3 unpaid sick days. If you've been employed for more than 2 consecutive weeks, you're entitled to those days. Again, they are unpaid. Your employer does not have to pay you, but they have to protect your job, ensure that your job still exists, and that you can go back to your job after those 3 unpaid sick days. Now, sometimes your employer will have a policy that is better than that. They will provide you with greater amounts of sick days, or they'll provide you with paid sick days, and they are able to do that. And if they do that, then that is what you're entitled to. So the minimum amount based on the Ontario legislation is 3 unpaid days. Often, like I said, employers will say, we know that's the minimum, but we're going to give you more. Okay, we offer our employees more. You get 7 paid sick days, for example, per year. And then that's what you get. You get 7 paid sick days per year. So very important to look at the actual policies in place. If there are no policies in place, then it's that minimum amount of 3 unpaid days. Absolutely, you cannot be fired for taking your sick days. One thing to note is, in general, you can be terminated for any reason, so long as it is not a discriminatory reason. So that's called a termination without cause. Termination without cause means your employer may not have a reason, or they might have a reason, they're just not disclosing it. It could be due to business needs or restructuring or whatever the case might be, that they're letting you go, and they're allowed to do that so long as they pay you the proper amount of severance, which often employers don't do, and that's where we come into to the picture. Now, if you are terminated, though, for a specific reason that is illegal, such as a medical reason or such as you taking your sick days, those would all be things that are improper reasons for terminating you. Even if it's a termination without cause, it would be illegal, and it would breach the legislation in Ontario, known as the Employment Standards Act, and maybe even the Human Rights Code, if you're terminated and it has something to do with discriminatory reasons. It could be your disability, it could be your age, whatever the case might be. So in the In the category of sick days, we're often dealing with a medical reason. And so if you're let go and you can tie the termination to the fact that you took sick days, that would be illegal. And absolutely, you'd be owed your severance pay in that case, and potentially even more money. Now, another important thing that a lot of people ask me, can your employer ask for documentation? So if you want to exercise your right to take your 3 unpaid sick days, your employer they can't require you to give a medical note any longer, but they can ask you to provide some sort of documentation that might set out the length of your time off, if there's any accommodations that are needed for the employer to implement upon you returning to work. That's the kind of documentation the employer might need. But in general, you get these 3 unpaid sick days. It's part of your rights as an employee in Ontario. So that is just an important topic. And now we'll get into a few more questions in the time we have remaining. We have a question from Mark on YouTube. If your company is dissolving a partnership at the end of the month, you'll be out of work as a result. You've been at the company for 5 years. You're definitely paid. Yes, you are going to be owed severance pay. And your 5 years of service is, again, going to be one factor for considering how much severance pay you're owed, along with your age and your position and your remuneration. Okay, we have a question from Nita Light on YouTube. When is an employer allowed to make changes to remote work protocol? Also a very relevant topic. A lot of people started working from home during the pandemic, maybe full-time, part-time. Now employers are often requiring employees to come back to work. So typically an employer can do that. They can ask you to come back to work. Each case will be different, though. It will depend on a few things. One, documentation. If you sign documentation indicating that you can work from home indefinitely, then your employer can't force you to come back to work. If they do, that would be a constructive dismissal, what we talked about earlier, a change to the terms of your employment. The term of your employment is that you get to work from home indefinitely and full time. And if your employer comes along and says, you can't do that anymore, we're requiring you to come back to the office 2 days a week, for example, that would be a problem. But if you always worked from the office in person, you then started to work during the pandemic remotely, and now your employer is saying, well, pandemic's over, so we're requiring people back at the office, at least part-time. That's usually within your employer's right. But again, I've seen various cases like this, and really each time is different. So it depends on the documentation, and it depends on your particular circumstances, how long you worked remotely, how long you worked in person. So we can review that more thoroughly in consultation. So why don't you contact us at help@employmentlawyer.ca, and then we will we'll address your question and more comprehensively. So that's it for today. We got lots of questions. We dealt with many important employment law topics. We're back tomorrow for another Q&A session at 1 p.m. with my colleague Thielen. So make sure to tune into that. And thank you for joining us. I'll be back with you soon for another Q&A session. Take care.